Everybody, we will call the meeting to order for the Civilian Review Board. My name is Dr. Chanel Jones. I'm the vice chair. I'm standing in place of Brooke Burns, who is our chair and is out today. So we have a robust agenda. The first thing that we need to do is approve the minutes from our previous meeting. Can I get a motion on that?
So moved. Second.
It has been moved by Mr. Fluharty and second by Pastor Nathan to accept the minutes. All right, thank you, everybody. And then moving on, we have Director Kate Bwc here, who is going to be giving an introduction and talking to us, answering some of our questions. So, Director Bwc, you have the floor.
Good afternoon, everyone. I have had the opportunity to meet all of you prior to this with one of my favorite accomplishments when I was in the mayor's office, which was helping to set up the first ever Civilian Review Board in the Office of the Inspector General. My name's Kate Bwc. I have been a lifelong Columbus resident. I have over 30 years of experience in government, most of it here at the city of Columbus. Some of it was at the county as a probation officer and bailiff, so I got to know the court system down there. My first 18 years at the city were served over at City Council. I was an aide to Councilmember Michael Mennel, who at the time was the chair of Safety Committee, so I've kind of been around the safety house my entire career here at the city. From there, I was placed in the Legislative Research Office again, mostly working on safety policy. I was able to move to the Safety Director's Office when Mayor Ginther got elected as a Deputy Director of Public Safety. At that time, my main responsibility was over capital projects for both police and fire. And then from there, I was appointed as a Deputy Chief of Staff in the Mayor's Office with purview over mostly public safety. I had some other departments that I was a liaison to. Some of my favorite accomplishments, I gave you one. The second was the REACT, which is the unit at the Division of Fire that includes CPD and social workers. They react to overdoses, and they do the follow-up and help people get into treatment. I've been active in their alumni group for a number of years now, because they always say you can help people get sober, but keeping them sober is where the work comes in. They have a big group of people that meet once a month with different activities for them and their families that has served to be a very positive kind of continuation of what CPD and fire and public health has done. Additionally, this is my absolute favorite. I was able to help secure the funding for the first ever public safety wellness center in the United States. And I was just out there a couple weeks ago, and we asked them if you could do one thing different, what would it be? And they said we would have made it bigger, which was interesting to us. It was okay, if you build it, will they come? And they have programming there every night. They have yoga, they have Bible study and recovery groups and counseling and peer assistance, and it's just been an amazing thing to see grow into what it is now. I have a bachelor's degree in criminal justice from the University of Dayton and a master's degree in criminal justice administration from Tiffin, and that's it. That's me.
Well, thank you. Definitely a robust background in public service, so thank you. So we sent you some questions.
Yes.
And let's just go ahead and go through those. If you have answers to them, I don't know if you wanted me to read them or you want to just read them and answer, or just go kind of.
Sure. I think your first question was, what was your expectations of IG's office and the Civilian Review Board? And, from the very beginning, the way that we saw when we set up the Civilian Review Board is that we needed a mechanism to start to rebuild the bridge between Columbus Police and the community. And I think between the IG and the Civilian Review Board, it's vital in ensuring that the members of CPD are carrying out their duties in accordance with division policy and with the applicable laws. I think that it's definitely taken, it's been a great bridge in starting to recreate that kind of community and CPD relationship.
Thank you, and I kind of jumped ahead. I actually should have positioned this a little bit first. I wanted to let everybody know that prior to this meeting, we put out a call to all of the Civilian Review Board members and asked them for questions to send to Director Pashadi in preparation for this meeting. Those questions, we compiled them, and then we sent them to Director Pashadi, and so that is what she will be answering today. We are going to stick to the questions that we have, and then we will move on with the remainder of the agenda that we have established for today. So probably should have started off with that. So, but thank you for answering that. And so the next question that we have here is, what is the process for recommendations that come from the IG's office and the Civilian Police Review Board to your office following the conclusion of your office's review? So,
if we talk about a disciplinary hearing in the director's office, it's laid out almost like a semi-judicial process. The focus officer has union representation. They have an attorney there. We have an HR rep, a court reporter, and depending on what kind of charge, we also have someone from the city attorney's office. And each side is able to present their side and give evidence. And then at the conclusion, I usually tell them that I'll have a decision within 7 days. To this point, we have not had any investigations that have come from the IG's office or the Civilian Review Board. My understanding is that there may be one on the way. So that'll be the first one that we actually have that comes from this body.
Thank you.
May I, do you want to run through all the questions and then have?
Yeah, we're going to stick to the questions here.
No, well, it was a follow-up
To-
clarification.
To her comment?
Yes, but
Go ahead.
I can do it after everything is done, or we can do it as we're going through.
You can ask for the point of clarification.
Yes. Is there any kind of, so the process for recommendations, is there any sort of way to report back to the Civilian Review Board regarding the status of these cases?
The ones that come to the director's office?
The ones that come to the, police chief or the safety director, we're not getting any feedback regarding where those recommendations rest. That is, are they in process? Is there a way for us to get a monthly or quarterly report back so that
I'm
we
sure
know
there
that in
is.
case number such and such, you recommended this, here's the status. And in case number so-and-so, you recommended this, here's the status.
Would you like that as a written report? Would that be?
That'd be great, yeah.
Yeah, we can, I think part of there's a question around here around a dashboard too, so we can think about the best way to track kind of a status. We're pending, there's a process. Here it is in the process, similar to kind of the way we've got a little bit of a flow chart of how cases go through, it would be helpful for us to just know generally where a specific case is at. But we can think about what might be best that's not too burdensome on your offices.
It would be just great to know that this has been handled, discipline as, was meted out, know the safety director disagreed with this recommendation, or, where the recommendations
That seems
ended
like
up.
a very reasonable request.
Thank you. Thank you. All right.
Very brief follow-up specifically to this, the process point. When you said that both sides kind of present, who is on in that situation, who is on, so you have the officer, and then who will be presenting the evidence on the other side in this particular instance?
So I guess I can only tell you the ones I've been through since I've only been up there for 4 months. At this point, we've had some EEO issues, and so we have an attorney in our office that handles all of our EEO complaints. So she's typically presenting the case for the city side. So in these instances, I would imagine that it would be someone from HR that would present the case on behalf of the Civilian Review Board, or whichever mechanism it comes to us.
Okay, and then I'm assuming that they're kind of in communication with the IG's office in terms of how to present, if they're going to be presenting a particular case?
Yes, if the city attorney's office is involved, both the review board and the IG is likely going to be communicated with so that we can make sure we have the appropriate information.
Great, thank you.
All right. Moving to our next question. Thank you, Director Prasadi. How is the Office of Public Safety working with the Columbus Division of Police to ensure recommendations are reviewed and, if necessary, addressed?
So each and every investigation and recommendation goes through the chain of command over at CPD. When there's a policy change that's warranted, it's sent to the R&D unit, which is research and development. So the process to change a policy is very thorough and in-depth. They first start by doing an investigation into best practices around the nation. They change the draft of the policy, and they make sure that it's in compliance with all of the other policies. In addition, they make sure that it would pass accreditation. At any given time, police is reviewing 70 to 90 policies for review, changes, recommendations. And so it's a very thorough and ongoing process that they go through. So each and every time that there's a recommendation, it starts through that process.
Okay, thank you. Okay, continuing on. This one goes to the dashboard question that was raised earlier. What are your thoughts about creating a public dashboard where citizens can review the actions taken during investigations in real time? And we were thinking something similar to like the dashboard that we had during the Safety Commission that was established, but of course, regularly updated.
Sure.
Things like that.
So I think that would be something that we would work on with the IG's office, since the original information would originate from them. Obviously, when it comes to the other end, then we would have the input there. But I would be happy to work with the Inspector General to figure out how we can get that done.
All right, sounds good.
So on that in particular, just one of the recommendations I would look at is the New York City Civilian Review Board process, where you have individuals who can look up their, one, obviously you can file a complaint online, but they can actually check the status of their complaint online, and then you can look up historical information there. So some of it's public, like the case number and whatnot,
Sure.
but then there are specific avenues that are redacted. Obviously, Ohio's got different laws, but that's one area that, of a best practice I'd recommend looking into is New York City's Civilian Review Board.
I'd definitely be interested in seeing what kind of software they use to see if it matches up, if it's compatible with what we have here. But sure, we can definitely look into that.
Perfect.
All right, thank you. Now, the next two questions actually pertain to body-worn cameras. And so the first one, it says, in the code, it states, and this is quoted, "Division of Police officers assigned a body-worn camera shall also activate the camera when an encounter becomes adversarial, or its use would be appropriate and/or valuable to document an incident unless otherwise prohibited by federal, state, or local law." Why is it left up to the individual officer's discretion as to when an encounter may become adversarial? Because that determination is subjective. Why isn't there a requirement that officers turn on cameras anytime an encounter with a citizen occurs?
So I was excited about this question.
All right, let's hear
And Commander Lip passed out the body-worn camera policy. So what we have in code and what we have in policy is different. And the chief has created a policy that's much more stringent than what the code says. So if you look at page 2 of the directive, sworn personnel shall activate the BWC when dispatched or upon self-initiated response to all dispatch calls for service. So then it'll go down, it'll tell you every single time that they have to turn on the body-worn camera, which is pretty much all the time.
All the time.
So that, coupled with the fact that if there was an event where somehow the body-worn camera was not activated, which we don't have that often, I think that our officers have found that the body-worn camera has helped them out remarkably since we started the program. But the new addition of the body cameras, the Axon second-generation cameras, have a post-event feature. And on that post-event feature, the safety director can approve video and audio to be retrieved up to 18 hours prior to the event. And we have a 24-hour look-back period on the cruise cameras.
Thank you. The next question, we're only sticking to these questions.
Quick follow-up question. As it pertains, follow-up / clarification as it pertains to that.
Is it a clarification?
I think so. So part of the policy is, so you mentioned part of this policy and directive here around special assignments. So, or one of the things that I want to mention was that a lot of the times this has come up is related to the special assignments piece, where you may not even have.
I think that's the next question.
So we're still going through the questions, so if you just hold off and let us get through the questions. All right. So the next question is that several board members are very concerned about the absence of a requirement of body-worn cameras for officers who serve off-duty. They are still authorized to use deadly force even when serving off-duty, but we will not have video footage if a police shooting occurs. This absence of video footage will create a crisis of credibility for the department and may spark community protests. Can you explain the role of that public safety plays in crafting body-worn camera policies and whether public safety has any plans on amending that policy?
So the original policies based around body-worn cameras were crafted with help from a body-worn camera committee and Deputy Director George Speaks. He actually became almost a nationwide expert on body-worn camera policy. And he's had calls from all over the nation since he's gotten it up and running. So we have pretty amazing policies with regard to body-worn cameras. We are currently working on expanding that. We just spent $19 million to equip every officer with a body-worn camera. Prior to that, we just had banks of them that when you came in for your shift, you would grab one out of the dock. Now we have it so that every officer has one and they have a charger. What we're trying to do now is figure out a phase-in program so that we have an extra bank of body-worn cameras that can be used by officers that are doing special duty. The issue now is that after an 8-hour shift, they need to be put on a charger, which is why they would need an additional camera. we're trying to figure out actually how many officers do special duty, because it would seem like not a great use of taxpayers' dollars to just buy 2 of everything. Also, the cost limitations on that, but I'm working closely with the chief to figure out how many we need to buy in order to get the most coverage. So we're in the process right now.
Okay, thank you. Those are all of the questions that we had. We would love to invite you back to give us an update, because there was a lot of things that were in process. So if you would be open for us to extend an invitation for you to come back and give us an update.
Absolutely.
We would love to have you back.
It would be my pleasure.
All right, thank you, Director Pashadi.
Are we going to have a question and answer portion for my questions that we might still have? Because I have one question from what she just talked about when it comes.
Follow-up to anything she just
That's
discussed?
what I'm saying.
Okay, yeah. I was about to say, if it was something additional that
No,
was
it's
not
nothing
sit in.
additional,
Okay.
because when we were kind of general in our description of officers on special duty, because one of the issues that we had were detectives that were on special duty who were not originally required to have body-worn cameras, wear body-worn cameras. So does that description include detectives?
Detectives wouldn't be doing special duty as detectives.
Was doing special duty on one case that we went over, and he was not required to have a body-worn camera.
So at this point, none of them are required to have them for special duty. It is recommended. What we're trying to do is to get the technology, buy enough technology so that they can use them while they're doing special duty.
If they decide they want to do so.
I think that probably we would revisit the policy if we had enough for the coverage.
That was my question.
Thank you.
I don't know whether it's more directed towards the IG when we get a little
Okay.
further on in.
All right, thank you. Any other questions as it pertains to anything that Director Pashadi addressed today?
I think in a future meeting, thank you for being able to come back. If we have questions, if the public has any questions of the safety director, it might be prudent for us to put out a call at some point at a future meeting when you come to either the board or we do another kind of town hall kind of series event, if the public has additional questions based off of this conversation. But
Sure.
really appreciate this.
Thank you, Director Pashadi.
Thank you.
Next up on the agenda, speaking of body-worn cameras, we have Commander Lip, who is going to be giving us a presentation on the body-worn camera policy. So the floor is yours.
Right, thank you. Okay, it sounds like everybody can hear me. Good afternoon. I'm Commander Jeffrey Lip over the Professional Standards Bureau. I am going to touch on the body-worn camera policy, which you all have in front of you right now. That should take about 15 minutes, and I will stay afterward and make myself available for questions if you have them. I do have a couple of our subject matter experts here with us, our Research and Development Sergeant Kirk Alt, and one of our information system analysts, David Stanizek. He is actually the BWC program lead, so if you have some more nuanced questions that I can't answer, I might defer to them if that's okay. But anyway, let's dive right into it. Before we go into the actual policy, I just want to provide an overview of the 2 different types of cameras that we have currently deployed. Both of these are made by Axon, which is a manufacturer formerly known as Taser International. We have the Axon Body 3, which I have right here. I'm actually going to step away for a moment and pass this around so that you can get your hands on it. All right. Yeah, I want to be able to pass it around so you guys can actually see, what it looks like, maybe, experience it, get a hands-on experience of the hardware. So we have the Axon Body 3, which is issued to all sworn division personnel. We have the Axon Flex 2 that is issued to some of our specialty units, including SWAT and NTAC. We've deployed about 1,900 cameras to date, captured about 1.1 million BWC videos. Everybody, when they get their BWC, they're given 2 different mounts to affix it to the uniform, because we have a few different variations of the uniform, especially in patrol. They're given a double molly mount and a wing clip mount. Here, it might be kind of difficult to see, but here's a recent picture. I believe that was at Red, White, and Boom this year. As you can see, Chiefs Potts and Bryant are wearing the traditional patrol uniform, and then you have a few officers there wearing the external vest carrier, and they're easily able to fix it using the wing clip mount. Regardless of how it is affixed to the uniform, it needs to be appropriate for the assignment, and it cannot obscure an officer's name or badge number. All right, and here's the helmet cam, the Exxon Flex 2 that I mentioned earlier. This is being rolled out by SWAT, and I've been told by the SWAT commander that this is going to be used in conjunction with the Axon Body 3 that's typically worn on the front of the uniform, or in their case, likely the external vest carrier. That way they get 2 vantage points of whatever operation they're engaging in. Okay, so let's dive into the policy that you all should have a copy of. And I'm not going to go line by line because I'm trying to limit this to about 15 minutes. I want to be respectful of your time. So it's going to be difficult for you to follow. So I didn't reference specific sections in my PowerPoint. But like I said, if you have any questions, I'll try to answer those at the end of the presentation. Okay, so we've had a BWC policy in some capacity since 2016. And over the years, we've had 5 different iterations of the policy. The last revision took place in April of '21. The policy that you have in front of you was recently approved by the chief and will be distributed to all personnel at the end of the month, and they'll be required to sign off on it in Powered EMS. And one of the more significant changes with this current revision is that it was combined with the cruiser video system policy because there were a lot of similarities, and it made sense to just combine it into one comprehensive policy. Okay, let's talk about BWC deployment. Personnel who are assigned a BWC shall wear it and have it powered on unless any of the following apply. This includes regular duty and overtime. If they're working an assignment where the BWC is exempt in a standard operating procedure or an applicable MOU. So for it to be exempt in an SOP, it has to be approved by an assistant chief. And I'll try to give you an example of some assignments that might be exempt. Like I said, over the Professional Standards Bureau, the majority of what we do on a day-to-day basis is administrative in nature. We wear business attire. We're inside of a police facility, not interacting with citizens or taking any enforcement action. So we will likely be exempt in our SOP, but also in the SOP, it will be explicit that if we were to pick up an overtime shift in patrol or work a parade on overtime, that we would wear the BWC, which is appropriate. Should also have it powered on and wear it unless performing an activity or in a location listed in sections 2, O, and P. And I'm going to skip this for a moment because I'm going to cover it in a later slide. Don't have to wear it if we're in a division facility not interacting with citizens or wearing the Class A uniform. And the Class A uniform is what we wear for ceremonial purposes, so a recruit graduation, promotion ceremony, funeral, that type of event. Okay, so moving on to civil disturbances or crowd control situations. Personnel responding to one of these situations shall wear the BWC and have it powered on unless they are in covert or plainclothes capacity. And absent exigent circumstances, personnel not equipped shall not interact with personnel or take any enforcement actions. Okay, so for special duty, it's not required, but it can be used provided it can be fully charged and all the videos uploaded prior to the beginning of the officer's next shift. And as the director explained, right now the biggest constraint is essentially resources. We just don't have enough cameras to make sure that we have a bank available for individuals that want to work special duty. But we just recently finished up rolling out the new body-worn camera policy where everybody is issued their own body-worn camera. So this is a step in the right direction toward increased accountability and transparency, which we know, of course, is important. And I do believe that the chief, if and when we have the resources necessary that she would be receptive to making this a requirement for special duty. Okay, so moving on to activation for dispatch calls for service. That's required when being dispatched or upon self-initiated response to a call for service. And we put this in the policy because we don't want to leave it up to the officer to decide when they're going to activate the body-worn camera. They might think to themselves, well, I'm getting dispatched to this traffic accident at this intersection. It's going to take me 15 minutes to drive there. I'll just activate it right before I get out of the car. Well, you know, law enforcement is pretty unpredictable. We never know what's going to happen. So if we wait till the last minute, you know, it could be a very volatile situation, you know, and we don't want the officer to forget to activate it or, you know, be distracted and take their eyes off of, you know, some sort of safety issue. So we make it easy. As soon as you're dispatched or you volunteer for a run, that's when you need to activate it. And that includes a 2-minute look back. So if I activate it now, it's going to record everything, both audio and visual, 2 minutes prior to when I hit the activation button. Does that make sense? Okay, perfect. Okay, moving on. All right, I said I would get back to this. So special circumstances for deployment and activation. The BWC shall not be used to record certain non-work related personal activities where there's an expectation of privacy. So think restroom, locker room. We don't want people activating, especially with the 2-minute look back. I think that is a pretty common sense approach. Shall not be intentionally activated to record privileged communication during routine non-enforcement related activities with or without the person's knowledge. And if an officer is dispatched in one of these circumstances, they have to activate the body-worn camera as soon as it's safe or reasonable to do so. Okay, for self-initiated activity, so personnel need to activate the BWC prior to exiting their vehicle, and if they're not in a vehicle, prior to approaching an individual on foot. Anytime they're going to take any enforcement action or engage in investigative activities, or anytime they make a citizen contact or where a citizen contact is likely to occur. So if I'm driving down the street, I see something suspicious, I want to investigate or I want to stop and talk to somebody, I better activate that body-worn camera. So as you can see, most of what we're going to be dealing with on the street, particularly in patrol, is going to be captured on video. And if a citizen, initiates contact with an officer, the BWC needs to be activated as soon as reasonable and safe to do so. An activation is also required for all of the following, and this is echoed in City Code. So we have requirements by law. It's Columbus City Code 1914-02, and that is activation of body-worn cameras. All of what you see up here is included in that statute with the exception of the 3 that are underlined. These are in addition to, so we actually go a few steps above what is required by law. All right, let's talk a little bit about search warrants. Those participating in the execution of a search warrant during a tactical operation shall activate prior to entry and record the knock and announcement at the entry door, including the statutorily required time delay prior to entry. This does not apply to no-knock warrants, and they need to record until the execution of the warrant has ended. And, by our definition, it's ended when the scene's secure and suspects or, persons of interest are no longer a threat. Okay, I believe Director Prashadi touched on this a little bit, or maybe she didn't actually. So we do have the capability of the BWC will automatically be updated if it's in the vicinity of a cruiser video system that's activated, and that applies to surrounding jurisdictions that use similar technology to the Columbus Division of Police. But both BWC and CVS cameras can be remotely activated by authorized PoliceNet personnel only at the direction and authorization of the safety director or her designee. All right, so when the BWC shall not be used to gather intelligence based on First Amendment protected activity unless there's a reason to do so. So if we are engaging with individuals at a protest, we're required to activate the body-worn camera for that. Or a strip or body cavity search for obvious reasons. Or for a lethality assessment screen. Continuing, if ordered to do so by a supervisor, it shall not be used. And this might be to preserve the privacy or dignity of an individual or place unless there is an injury to an individual as a result of a police action. And if a supervisor does give approval to not use a body-worn camera, it must be given verbally, over the radio, or in an operations plan. Okay, when it should be deactivated, when gathering information from confidential informant or source. And the reason that this is important is we don't want to, if somebody is cooperating with the police, we don't want to record that interaction, because if somebody does a public records request and sees that somebody's trying to assist us, that, you know, might not end so well for them, and it could jeopardize their safety, so we want to avoid that. Or when speaking with the division's legal advisor, covert or investigative personnel, supervisor, or other sworn personnel while not in the presence of suspects or citizens. So this could be, you know, we're at the roll call table, you know, the sergeant's providing some training, something like that. There are no citizens in the room. Unless approved by a supervisor. The supervisor can always tell somebody that they need to turn it on. Okay, I'm sorry. Also at a guard duty at a hospital, we will routinely guard somebody at a hospital for sometimes hours, days, weeks on end. They're routinely receiving medical treatment during that time. It's not really appropriate for us to record that activity, but we still need to activate it if the encounter becomes adversarial, or we need to take some sort of enforcement action. All right, stopping a recording. We need to make sure that citizens cannot tell us not to record, but a supervisor can. And we shall record the entire enforcement action unless approved or permitted to stop by a division supervisor, a sworn supervisor. All right, we have some additional responsibilities. Ensure at the beginning of the shift that the BWC is fully charged and operational. Previous recordings have been uploaded. And notify a supervisor at the first reasonable opportunity if there's an issue. The battery's almost dead, there's a malfunction, and they'll make accommodations to get that repaired or swapped out. Documentation, we need to make sure that when we don't record the entire incident, we shall provide justification expressed verbally before deactivating the BWC. If it's dead or there's a malfunction with the BWC, we need to make sure that we're including that in our paperwork, the computer-aided dispatch system, or the electronic reporting system. There are some additional prohibitions. Personnel shall not tamper, erase, delete any recording, shall not disseminate unless any of the following apply. Personnel shall also not duplicate or download to a personal device. We don't want people using their personal cell phone to take a video of a recording and then sharing that with friends and family. That's inappropriate, so it's prohibited. And shall only share with authorized persons for a legitimate purpose. A few miscellaneous items. There's a 2-year retention period for all BWC recordings, but this can be extended if needed. Personnel may review a recording prior to making a statement or writing a report. And this is something that is contractually afforded to sworn personnel in the FOP contract. Talk a little bit about accountability and oversight. This is something that the chief just added in recently. It's never been in our BWC policy before, but she is making it a requirement that all sergeants randomly review at least 2 body-worn camera videos for each subordinate officer per month. That's just the minimum, but sergeants and other supervisors are routinely reviewing probably dozens of videos every month as part of administrative investigations. But this is just another layer of accountability that the chief wanted added to policy. Any review needs to be documented on the appropriate form. And I put this in here because we do hold our people accountable. Since 2018, we've had 163 instances of discipline being issued for violation of Division Directive .07, the vast majority of which were low-level discipline, documented constructive counseling. There are a couple of written reprimands in there, and those were instances where the officer was subject to progressive discipline. So maybe a month ago, they got issued a DCC for failing to activate the BWC. And then yesterday, they did it again. So, by the contract, that can be progressed to a written reprimand. And I know I talked fast and kind of blew through everything, but that is all I have. So please, any questions? Yes, sir.
I did notice that you said that the BWC is not supposed to be used, say for instance, if somebody is guarding someone within a hospital.
Right.
Medical attention, things such as that nature. But there was an incident that where we had in one case where a police officer was guarding an individual that had been shot. He did not use his BWC.
Okay.
But he used his own cell phone. Is that unlawful?
Well, I don't know that it's unlawful, but it sounds like there could be some potential policy issues associated with that. So, and this is one of the investigations that you've already done and have forwarded to the chief. So that will go through a chain of command review. After the chief sees it, she'll send it down. Everybody in that officer's chain of command will make a recommendation, and they'll address any potential policy violations and make a recommendation. That could range from, this can be resolved through training, or it can, needs to be a documented constructive counseling, and so forth. So, yes, sir.
Thank you for the presentation. So just as when now we're trying to get the process so the board will forward along maybe a recommendation for potential discipline for a particular officer. In that instance, then, when it goes to the chain of command process, if there is already kind of, how are you going to, how do they merge? There's a finding from the IG's office, but then the CPD has already determined a policy violation separate from that incident. Is there a process in place to, merge, so basically so that we know the progressive discipline process is happening? So what does that process look like? Do we have a sense of what that looks like now? I don't know if you can answer that or if anybody else can.
So I think so is your question essentially, how can we see what the outcome of these cases are? If there are policy violations and, training issued or discipline issued, you would like to see that, right? Because are you not necessarily addressing what could be deemed minor policy violations in your investigations and investigative review? Is that right?
So I think part of it is basically, let's say there's we find in a separate case from a separate complaint that there's been a violation of, let's say, the body worn camera policy, right? But you all, through the course of another process, that same officer might have a violation of that policy as well. Okay. In a separate situation. Is everybody communicating that this is violation number 2 or number 3 or what does that look like? Right.
So we actually have the discipline tracking system. So anytime an officer is disciplined, it goes into that system, has the incident date, the date of issuance, and there are some contractual considerations there too, because we can't progress discipline if they haven't been issued it. So that's when, chain of command review and investigative timelines come into play, because somebody, could be under investigation for failing to activate their body-worn camera. If that investigation takes 6 months, and during that 6-month period they have a violation in there, contractually for us it's going to be difficult, So they have to be put on notice, essentially, before we can progress something. Yes, ma'am.
I just have a question. Body-worn cameras, it seems like have been really beneficial to the officer as well as to the citizens. Mm-hmm. And it seems, is there anything in the workings where body cameras will be required for special duty and guard duty at the hospital? Because I'm not going to go into specifics, but the guard duty at the hospital, we've had most of it goes beautifully, and the officers are doing exactly what they need to do. But then you have situations where there have been mask situations, and the nurses have issues, and it's a subjective discretion. It's the officer whether the situation is adversarial or not. So we have no body camera to help us. Is there something that you are looking at to see for a change of policy down the road to have body camera whenever an officer is on duty?
On guard duty? No, I'm not aware of anything that's in the works. And I think that the reason that was one of the exceptions, if you will, for not recording is, because they're, there to receive medical treatment. A lot of that's sensitive. If somebody does a public records request, it's very time intensive to redact that information. But anytime, if you're right, it is, I guess up to the individual officer to determine when something becomes adversarial, but they know that that is subject to your review and your recommendations in their chain of command. So they have to be able to defend that in in an interview, they're all unique circumstances. So I would imagine that they're going to have to provide some justification for not, especially if it's a situation where they're going to take enforcement action or it is an adversarial situation.
Call on Director Fashada, because you touched on this a little bit in your presentation today. Do you want to reiterate some of the things that you said pertaining to that?
As far as special duty goes?
Yes.
Yes, ma'am. So the chief and I are in the process of looking at how many body cameras we would need in a contingency for officers that do special duty. At that point, if we can get the resources, which we're working towards, then there would be probably a revisitation. We'll revisit the policy in order to make it so that you're required to wear a body-worn camera during special duty.
Thank you.
Just, I'm not sure what the policy is, but if you're an off-duty officer, you come upon a situation that requires, your assistance. Is that covered anywhere, not special duty, but off-duty? Can an off-duty officer use deadly force in breaking up a, situation that they determine is, where deadly force is required? And second, where do body-worn cameras fit in with off-duty officers?
So we've never given any consideration to body-worn cameras for off-duty officers, but it is, once you're an officer, you're on duty 24 hours a day, and you have a duty to intervene. But I'll let Commander Lip fill in.
Yeah, and I think there would be some contractual considerations there if we required, officers to wear a body-worn camera essentially when they're off duty, because then would they be considered on duty, and would they need to be compensated for that? I think would be one of the bigger questions. But to answer, I think your first question is, if there is something serious, you're driving down the road and somebody's holding somebody at gunpoint, I think, for the most part, the expectation is that you're going to somehow intervene, or do something to assist that individual. But there are in policy certain circumstances where it's explicit that we cannot take action for like minor traffic violations.
Yeah.
We don't want anybody in their personal vehicle making a traffic stop, anything like that. But if it is something serious that's life-threatening, then that could definitely happen.
I'm just curious because when an officer chooses to draw their service revolver and intervenes with deadly force, this, just like the special duty situations that we've had on multiple occasions, this actually has come up repeatedly, the special duty situation. So we're not thinking theoretically here. There's been a number of cases that have come up to us involving special duty officers. That's why we're pressing the point where there was no body-worn camera evidence. But I'm just, again, we're serving as a bridge between the community and the police department in order to bring about understanding, and I hope some degree of healing in the relationship of the community with the police. And I hope that it's working for the police and not, as well as the community, that they feel that the Civilian Review Board has been really a fair and impartial arbiter. But I can envision a situation where an off-duty officer is going to find themselves without any corroborating evidence for their perspective of the incident. The public has gotten used to body-worn camera evidence. When there's a shooting, they're demanding it, as we've just seen in recent days. And I don't know if there's a technical solution for this regarding, the drawing of a revolver. I don't know how that might work, but we're interested in making sure that officers are protected as well as the public. So I don't know if there's anything that could be done, but I'd suggest somebody looking into that as a situation where we're expecting somebody to use deadly force and there's no evidence.
We're in the process of collective bargaining right now. Not to say that would be brought up this session of collective bargaining, but it would definitely be something that would have to go in front of the union. So that would probably be a pretty big hurdle. Just being realistic.
Thank you. Any more questions? Were you about to say something? Oh, okay. Thank you, Commander Flip.
Thank you, ma'am. Appreciate it.
Thank you.
Thank you. All right, moving on. We have a review of a case, and then we're going to go through the remaining cases from our August meetings, and we'll talk about some assigned cases. But we have case 22-02224? 224? 0224?
Man, I hope that wasn't mine.
Who had that case? Was that you, Matt? Was it?
Nope. Really? Me?
I don't think this was ours.
I think we
We
completed
covered
ours.
ours, yeah, we completed ours.
We were incredibly efficient.
Stephanie, do you know whose case 0224 belongs to? The mystery case. You sure that's not yours?
I'm trying to think why it even went back. I know Pastor Nathan had a question on it. Hold on, guys, I normally know. No, you had the.
It was assigned to your committee.
I don't have last month's cases.
It was
with
assigned
me.
in June. I'm not sure why it's up here, but it was assigned in June.
It's
Or is it a 22? Is it a 22 one?
2022-0224, and it was sent back because Pastor Nathan had a question, you guys, regarding the policy.
I'm sorry, I don't have the case in front of me. I just brought my August cases.
I believe we got the question answered if that was our case, but I'm gonna go back and see here. While we look that up, we'll table that case, and then we will go on to review of the remaining cases from the August meeting. We have 23-143, 23149. Are those yours? All right, Matt?
So the first one.
Yours.
Certainly. So case number 23-0143. In this case, the complainant alleges that a CPD detective showed a friend and her mother sealed court documents involving the complainant in an unrelated case. The DIG's investigations to this case revealed that the the CPD detective, while interviewing the complainant's friend and her mother concerning possible child abuse of the friend's daughter, verbally told them that the complainant previously was accused of being involved in a sexual situation with a minor and to keep her daughter away from the complainant. The IG's investigation also revealed that the CPD detective did not share or show any documents pertaining to the previous investigation of the complainant, nor were those documents sealed at the time of the detective's interviews. The IG's recommends that the allegations be closed with the finding of unfounded, and I motion that we agree with that, agree with the finding of the IG's finding in case number 23-0143.
And it has been moved or motioned by Mac and second by Mary. Everybody, did you want to do them all together? Did you have different findings?
Yeah, well, 149 is Mary's.
Okay.
Case number 2023-0149. The facts on this case are the complainant brought a complaint to the IG stating that the officers who came to her home for a wellness check were rude, condescending, forced her to go outside, and pushed her fiance back inside. So there are 3 allegations. She alleges the officer was rude by saying, "I'm a cop, and what I say goes." Number 2, officer forced her to go outside her home when she did not want to. Number 3, third officer used excessive force when he pushed her fiance back into the house. The IG investigated. They reviewed CAD data, ECC data, BWC cameras. They then reviewed CPD policies and procedures. Review of this showed that the call for service was dispatched first as a DV, domestic violence. First officers arrived, and the first officer arrived and was told by fiance that the complainant was in the shower and off of her meds and having a meltdown. The fiance explained that they had gotten into an argument. Officer was in the living room. He asked the complainant to put on her clothes, come out, and talk with him. He explained that the neighbors had called because of the excessive noise, and he needed to get her side of the story. Both of the individuals said no DV. Officer said he still needed to investigate it. Complainant got dressed, went outside with the officer. They talked. She explained why they were arguing. However, she was still irate about the officers being there. Fiance attempted to come outside while they were talking. Second officer told him stay inside because they needed to speak to her alone. Fiance attempted to come back outside, and the second officer put his hand on his chest to guide him back in. This was on the BWC, so they could talk to her. They explained they needed to talk to parties separately on a DV. They both explained that there was no DV, and the knife that was on the table was for cooking. Both were continued to be verbally combative with the officers. Officers did establish that no violence occurred. They updated the CAD notes and left. The recommendations by the Inspector General were unfounded as to being rude. There was no evidence of being rude on the body camera. There was no force. He just guided the fiance back into the house so he could speak to the female alone, and no force was founded. Our committee concurred with the finding of the IG, so at this point, we move to accept the findings as to case number 2023-0149.
Thank you. Moved by Mary, second by, I think we got Mark first on that second. All right, you have another case?
Case number 23-0151. In this case, the complainant was involved in a 2-car accident. Complainant appeared to be injured, possible concussion. Medics arrived on scene, diagnosed complainant, and were going to transport because complainant showed signs of a concussion. Officer advised complainant that since there were no injuries, that a report would not be taken. Complainant decided not to go with the medics, but instead stayed on scene to ensure her vehicle was towed. Complainant later contacted the DIG to file complaints alleging the officer informed her that he would file an accident report. And number two, the officer told her that she should not leave the scene if she wanted her car towed by her insurance company. The IG reviewed the Bwc footage of the incident, which revealed that the officer did not inform her that he would file an accident report, nor did he tell her that she shouldn't leave the scene. He did state that she should wait if she wanted her car towed by her insurance company. The problem is, our subcommittee, agree with the findings of the IG, unfounded on both. And I motion that this board agrees with those findings also. However, the officer himself thought that she might be injured. So actually, a report should have been taken. So that's neither here nor there now. It's a done deal. But even though the officer said to her that he would not take a report because there were no injuries, in that same breath, just prior to that, he told her that she might want to go see a doctor for possible concussions based on her behavior. The medics were going to transport her because of possible concussion. So there had to be some type of injury, or at least a thought that an injury occurred. So the report should have been taken. The other things that she is alleging didn't actually happen. He didn't say he would file a report. He actually said that he wouldn't. And he did not tell her she had to leave. He told her that she should wait a second for that tow truck to come. All that being said, I motion that we agree with the findings of the IG in case number 23-0151.
Second? Second. And then Kyle?
So I'm having trouble following that one. So you're saying that there should have been a filing of a report?
Absolutely.
So is that if you don't file, is that a violation of some sort of policy, or should a practice? I mean.
Yep.
Okay, so is there a reason that there was not a sustained
Because
Department
the
inspection?
complaint was not that.
Well, I know that.
Yeah,
So-
yeah.
But in terms of, over the course of the fact-finding process with the Department Inspector General, adding a sustained allegation from a Department Inspector General initiated allegation and sustaining it, is there a reason that that did not occur?
What I would say is that was a question that should have been brought up to our office ahead of time. Right now, I don't have enough information to make a comment on this. I can look at it,
Yeah,
but I don't have enough information right now.
Right, so there was a question sent, and it was answered. Like I mentioned, the complainant didn't complain about the.
Yeah, that's fine.
Right? So I agree with that. We agreed with that. Her complaint probably should have been that he did not take a report.
Yeah, so I think, understand that piece, but I think, at least the way I was understanding the process, the way it was working, is that even if a specific complainant did not make a specific allegation, if during the course of the investigation, the fact-finding, that the Department Inspector General found of a potential violation, that would then be added on as a sustained allegation. And so my recommendation in this particular instance might be to potentially hold that for further review, because I don't feel comfortable moving forward with a recommendation without, with this potential policy violation that we're.
May I ask, Matt, what was the question that you did send to the IG's office? You said you sent a question?
I can't remember how I worded it, but it was, I knew that he should have taken a report simply because there was an injury. you don't have to take a report when there's not an injury. He said himself, the officer said himself, the officer asked the complainant what happened and talked to her with the other driver as well. The complainant appeared as if she had suffered a head injury. That's the officer. Then in the very next sentence, the officer advised her to see a doctor, go to the emergency room since she was speaking slowly. The officer advised the complainant, he told her about making the left-hand turn, the other driver will be at fault. However, since there were no injuries out of the accident, the complainant would receive a piece of paper to write her information down. Both parties would exchange information. So, as you can see what I read, he told her that she should see a doctor, go to the emergency room because she was speaking slowly.
So,
So
did you want to, like Board Member Strickland said, did you want to hold off on this?
Well-
Or did you want to move forward with voting? Or did you want to send it back to the IG's office?
Chair Jones, before we make a decision, the IG doesn't have any time left on this one, but the board can initiate their own complaint and sustain it if they would like to do that versus sending it back to the IG.
So in a situation like that, then what happens from there?
So we would vote on the finding here, but we would open up another complaint basically against the lack of taking another report.
Couldn't we just couldn't we sustain a CPRB sustain allegation based on the fact finding that was presented here? Is there a limitation from us doing that?
No, that's what we were saying. We can sustain.
Oh, but yeah, not a separate complaint.
Oh, you don't want to do a separate complaint?
I'm sorry, you mean a separate allegation, like a board-initiated allegation and then sustain it?
Yeah.
I think that's right, it's just a difference in language we're
How
using.
Okay.
how we're saying it, but we're
Same
saying the
thing.
same thing.
Whatever
All right.
works.
Well, sure.
Do you think that's, I mean, I'm just basing this off of the conversation here. But you said, that's what you said.
I mean,
It's yours.
Are you moving to sustain an additional allegation?
No, I'm not.
And could you, okay, so,
Okay.
thank
I'm
you.
not.
Well, okay, but.
All right, so we have a motion and a second on the floor right now.
Yeah, and I think we're in the discussion period. What, I'm just want to get a sense from you, why you wouldn't, if you yourself had mentioned a report should have been filed here, is it because maybe you would have been more comfortable that finding maybe coming from the IG's office, or?
No. I would have been more comfortable had it, the timing, I look back, we're talking February, and we're September now. I don't think there's any reason at this point. Had it been earlier, then yes.
Well, I think there are going to be cases that we review that are going to be early or late 2022. I think that the fact is that it is now brought to our attention, right? We are now reviewing it, and this is the decision that is then made. I think it is perfectly within the purview of the police chief and the safety director to make their determinations from there. But if that is a finding of fact that is seen here, then I don't know how we want to word the language of we saw a potential policy violation that's part of the findings, and we would want to forward that along for review.
I'd also caution the board about coming up with some sort of kind of superficial timeline or time frame. A violation is a violation, whether it happened 3 months ago or 8 months ago or a year and a half ago. And if you make a decision not to do something because you think it happened too long ago, then moving forward, you need to be really consistent in kind of asserting that timeline, and that could prove to be challenging over time. So just a word of caution about that.
So then?
So given that new information.
So given that,
Yeah.
okay.
Just so we're consistent.
All right.
I was trying to be reasonable, right?
I guess also, just for a point of clarification, the original finding of the IG was related to the lack of a crash report? Or something different?
Different.
Okay,
And that
right,
was sustained.
okay.
That was unfounded.
Right,
Unfounded,
so
right.
if it's going to be board-initiated, motion, second, vote on the initial finding, and then a second motion on the new allegation coming from the board, yeah.
Got it. Okay. We can work with that?
All right, so we currently have a motion and a second for the initial finding from the IG. All those in favor, show of hands.
Yeah, I thought we were voting them all together.
The initial, we're,
know, but I thought we were lumping them all, because we didn't vote on the first case.
Yeah.
The earlier cases, we did not vote on.
we were gonna vote on those together, but this one has to be done separately because it's a,
Separate issue, just for cleanliness of
Yeah.
the voting, just to keep it clean. I would just do this one separately now.
Okay.
all right. Let's do this again. All right, so we have a motion and we have a second. All those in favor, see a show of hands. Thank you. Now,
If I may, I do have a recommendation, though. Just so that we don't get ourselves all mixed up and messed up. How many more cases do you guys have left to go over?
Several.
Okay, I would recommend that we go ahead and vote on those ones that they've already done, and then we move forward, because when we've had a gap in between.
before we voted on, I was gonna list off all the numbers, so we would be familiar with it, just for cleanliness of notes and minutes and all of that stuff. But you have a second motion. Hear that?
I thought I was going to get time to take a break and write that, but,
I can do it.
okay, Kyle, you-
So this would be a motion for a board-initiated finding of a sustained allegation of a potential policy violation for not filing a report,
for failure to.
for failure to file a report when perceiving an injury, in this case, on this
Second.
case that we're reviewing now.
This is case 151?
Case 151.
Yep.
0151. All right, did we get a second? I'm sorry.
Yep.
That was no. Okay, so we have a motion and a second to initiate an investigation on that?
Well, not investigation.
Oh, find a sustained, sorry.
Yep.
Okay, all those in favor, raise your hand, show of hands. All right, thank
job,
you. Your next one. I have 172, is that correct?
The summaries are good.
That is one of my, whose is that, Mary?
It's Mark's.
Mark? Okay.
On February 21st, 2023, the City of Columbus Department of the Inspector General received a complaint alleging police misconduct. The complainant alleges that on February 20th, 2023, between the hours of 4:50 p.m. and 8 p.m., he called 911 dispatch to report a burglary that was occurring at his property located at 1146 Barnett Road. The complainant stated he placed a call around 4:50 p.m. and he waited 3 hours for police to respond to his residence. The complainant stated he watched the individuals rob him while he sat in his vehicle in the parking lot adjacent to his residence. The police arrived and captured the suspects. A short time later, he was contacted by the 911 dispatch to go to the scene. When he arrived, noticed the suspects were going and questioned the officers regarding the suspects' whereabouts. The complainant stated an officer informed him the subjects in the van had been released from the scene, and they, officers, had been notified not to contact the complainant regarding the incident. After a review of the computer-aided dispatch report, the unit history report, the patrol review screen printout, the preliminary investigation report, the body-worn camera footage from the responding officers, the CAD summary reports for 911 dispatch runs for Zone 2 per precinct 9, 13, 4, 14, and 20, and policies and procedures for the Emergency Communication Center, ECC, and the Columbus Division of Police. The investigation revealed the following. On the day of this call for service, numerous priority 2 911 runs were dispatched in that zone. which required an immediate officer response. While there was an extended delay, 1 hour and 51 minutes between the times the call for service was placed and the time it was first dispatched. However, there was a minimal delay, 8 minutes, between the time the call was first dispatched to the police and time the police arrived at the scene. Once officers were made aware of the call for service, they immediately responded. Therefore, it is recommended that this allegation be closed with the finding of unfounded. When the officers arrived, they investigated the 3 male suspects who were at the scene. The officer observed nothing suspicious and found no probable cause to make an arrest, so the suspects were allowed to leave. Therefore, it is recommended that this allegation be closed with the finding of exonerated, as the officers' actions were supported by CPD policies and procedures. In addition, it is recommended that the complaint be forwarded to the leadership at ECC for further review and investigation into the no-contact owner entry by 911 dispatcher and the delay between the time call for service was placed, requested, and the time was actually dispatched. I am going to call for a motion to concur, but I will reserve a comment after the second.
Do we have a second? Second. Comment?
The actual real issue here was actually with the 911 dispatch. The officers did not get it timely, and there was no check mark on to actually talk to the complainant. That's where the problem really lied. But as far as the report and the investigation, it was spot on.
Thank you. All right, your next case, 193.
193, in this case, the complainant contacted the DIG and filed a complaint.
Excuse me, I'm sorry. Did we get a second on that?
Yes.
Oh, we did? Oh, I'm sorry.
Contacted the DIG and filed a complaint alleging that officers used excessive force when taking the complainant into custody. A pink slip. Concerned parties contacted CPD because they felt that the complainant was having a mental health crisis. Complainant was not willing to go with them to the hospital at that time. Officers explained that the complainant had to meet a certain criteria in order for them to take him involuntarily. Officers spoke with the complainant and determined that he did not fit that criteria to force him into emergency hospitalization. The DIG reviewed the Bwc footage of the involved officers, which revealed that the alleged assault by CPD officers did not occur. In fact, there was no physical contact at all. So I motion, and our committee agreed with the DIG's findings of unfounded, and I motion that this board concurs with the findings of the IG of unfounded in case number 0193.
Is there a second?
Second.
Thank you. All right, moving on to your next case, 215.
Case number 2023-0215, statement of facts. On March 2nd, 2023, the Department of the Inspector General received a complaint alleging that the complainant was pulled over for a traffic infraction. That officer put a gun to his head and threatened to kill him if he moved. That's basically it right there. The DIG reviewed the body-worn footage, the CAD, the unit history, statements from the complainant, officers, policies and procedures. A review of the BWC footage of Officer A, I believe there were 2 officers. Officer A showed that he was asked to stop complainant for failure to signal. The license plate was relayed to the dispatcher and it came back a 50 attached to the tag for larceny, meaning a 50 means that there is a warrant for a misdemeanor. However, when the officer was interviewed, Officer A, so we have Officer A indicated that he believed that the complainant was a wanted felon. So what he thought it was, he misheard. He thought it was a 50A, meaning a wanted felon. So he pointed his weapon at him. He thought 50A and not a 50. He elevated his response, believing that complainant could be dangerous. Officers admitted to profanity and also said the complainant complied with his orders. Part of the interaction was not recorded on the first officer's body cam since he could not explain why. He could not explain why. He thought there could be a software issue. However, we have body cam from the other officers, so this is not a big deal here. Officer H was interviewed. She stated that she moved to driver's side to assist with the arrest. She verified a warrant attached with the owner of the vehicle. Warrant attached. When interviewed, she did not verify whether it was a 50A or just a 50. BWC for Officer A picks up again after this little bit here that was picked up by Officer H body cam, and shows that Officer H is trying to calm the complainant down. The complainant is very upset about that gun being in his face. Officer A eventually realizes that the warrant was a misdemeanor warrant, not enforceable since it was out of the pickup radius of the agency that filed the charges. The agency is not going to drive to Columbus for pickup. Officer A stated he erred during the interview here, and the complainant was given a citation after all this for failure to signal and released. The findings of the IG: allegation number 1, police officer put gun to head and threatened, exonerated, because officer believed that it was a felony warrant and acted in accordance with that belief. This is the finding of the DIG. The DIG also had a subsequent allegation indicating that Officer A's actions of using profanity towards the complainant, stating, "Show me your fucking hands," violated CPD policies and directives. The recommendation is this violation be sustained. So our committee reviewed this. We accept the finding of the IG as to allegation number 2, which is the DIG's allegation that profanity was used. As to allegation number 1, excessive use of force, we sustain the allegation of the complainant. Is that what we did? Hold on, I'm sorry. Yeah. As to allegation number 1, we move to sustain it. We believe that the officer violated procedure for high-risk traffic felony stop, even though, so he himself indicates in the body of the statements that he believed this to be, he believed it to be a felony traffic warrant, which is a 50A. He admitted to pointing the weapon at this individual. Now, when our committee reviewed this, we would not have known what this was, but we had Mac in our group, and so he indicated that we needed to take a look at the policy here. And the officer indicated that this was a high-risk traffic felony stop. And if you look in the policy, it's not the policy, it's the directives, I believe, Mac. What you have to do, you don't simply, as an officer, walk up to somebody and put the gun in their face. You stay behind the cruiser, and this is very, I'm just giving the basics here. You stay behind the cruiser, you give verbal commands, you get the individual to interlace their fingers, they walk backwards to you, because as Mac indicated, safety is first, and you want to protect yourself, and you have your partner backing you there. And your one officer is cover and has the gun, the other verbalizes to get him back to the cruiser so they can cuff him. And you don't just open yourself up, because the individual could have a gun, and you're opening yourself up with a gun in his face, he could shoot you. Search, and so at this point, when you've got him cuffed, you search him, you put him back in the cruiser. And at this point, you would find out what type of warrant it is and that it's out of radius. And so that's the reason why our group decided that we would sustain this allegation. So at this point, we move to sustain allegation number 1. We believe officer violated procedure for a high-risk traffic felony stop, even though it was, and we also recommend that he review Traffic Crash Investigation Directive 5.05 because he violated that particular directive, and also vehicle stops and approaches, which is Chapter 5, Issue 2.
Got a question?
Yeah, before we vote on anything, what was the IG's findings on number 1?
Exonerated.
Okay.
On all the allegations?
Well, there's 2 allegations. One was brought by the IG because of the profanity. And we sustain, we agree, excuse me.
Okay, and then the other one?
The other one was exonerated because the IG indicated that the officer misheard. He thought that it was a 50 instead of a 50A. But in the body of the statement, he indicates that he thought it was a high-risk stop, right?
Yeah.
And so he indicated that he had, it's in the body there.
Yes.
Okay.
You're good, Mayor.
So, yeah, I think that's where I'm mainly concerned. So I appreciate your subcommittee making that finding.
I appreciate
it is slightly concerning in terms of where the IG's office made a separate determination here because of this situation seemed to have been a policy violation, but I don't know if you all asked further clarification questions.
We absolutely did, and we got the,
would you mind reading those?
yeah. Let's see here. They sent us, okay, so as to 215, let's see, this is 228. What we asked on this one here was the policy that they reviewed. So what they sent us copies of traffic crash investigations, and which is, let's see, policy number 5.05. And under that, it gives what must be done during these situations. And it's very long and involved. I'm sorry.
Wait, are you talking about the questions that she asked and then you wanted the answers?
Are you
what
getting answers from?
What questions did you send to the IG?
I simply, in this situation, I asked for a copy of the policy, the traffic crash investigation policy that they used and directive. And they did give us
Okay, so that's no questions pertaining to like
How they
came to the determination or what for some of the factors, the exoneration?
No, because it was clear.
No, not you all. How they came to this determination.
The DIG, and I don't want to speak for the DIG, but they indicated that the intent of the officer misheard. So it was not, I mean,
Yeah, well, I don't.
So if the officer, I'll go ahead.
Yeah, I mean, if there's any, and I know if there's any opportunity for the IG's office to provide further elaboration, that would be helpful. But again, I don't want to put anybody on the spot. But that would be helpful for me because based on this finding from your subcommittee, that makes sense in terms of moving forward. And so I'm just a little surprised that that wasn't put forth from the investigator in this particular case.
okay, so let's ask at this point.
Just offering a little clarity on this case, I do remember that the officer's actions when he approached a car was not totally based on the information that he received from radio dispatch. A lot of it had to do with the orders and his interaction with the person as he was approaching the vehicle, which is the reason why why the finding was exonerated. It wasn't just, it was the totality of everything that occurred. So it was not, the officer's response, again, was not strictly based on the radio communication. It was received on the radio communication as he was approaching the vehicle, but also based on when he was approaching the vehicle and talking to the complainant, what the complainant was, his actions at that time.
Okay, so there were some other factors to take into consideration. Reverend Tatum?
I just want to make sure I got clarity on this, because I heard what the IG said, but Mary said that the officer, within the body of the report, the officer said
Okay, now I'll
that
read it.
this was some other type of a stop.
No, it was a traffic stop.
No, but you said something else in there, that there was another part in the body where there was something about a forcible, this was not a forcible stop or something in there.
50A?
The warrant, Mary.
The warrant, 50A and versus 50?
Oh, yeah. They received,
So the dispatcher dispatched it as.
okay, the license plate of, was relayed to was relayed by the dispatcher that it was, there was a 50 attached to the tag for larceny. And that means it's a petty theft. There's a 50, it's a misdemeanor for a petty theft.
Yeah, but there's another part of that.
That meant okay, here's the part that you might want. Eventually, the first officer's body cam picks up, and it shows, the next footage shows Officer A pointing his handgun at Mr. Complainant and ordering him not to move while using profanity, stating, "Do not," et cetera, et cetera. And Mr. Complainant was observed being very concerned about being shot and holding his hands up in an effort to protect his face. So after seeing this, reading this, our committee, from the body cam, and having Mac's input, we have Officer A with a gun in the complainant's face. We have Officer H somewhere on the driver's side. As she indicated, she came over to the driver's side, and Mac, thank God, was able to put the directives in some kind of an order for us, because they're very long, and so they're both on one side, and they're not following what's taught and what's in the directive. So it's a violation of the directive.
Okay, so I just want to make sure I'm clear then in terms of the allegations in your committee's findings.
Sure.
So you disagree with the IG on allegation number 1.
Correct.
And you agreed with IG on their finding for allegation number 2.
Correct.
Okay.
And the reason is because Officer A thought it was a felony traffic stop.
That's what I'm trying to.
Exactly.
And did not follow the proper procedure.
Exactly, thank you.
We have a Deputy
Period.
Director Blunt, would you like to?
Just a point of clarification, they didn't find that information out about the warrant until they had already made contact with the person. Had they known that prior to, it would have been a high-risk stop, like we're discussing right now. But because they had already made contact with this person, they were already interacting with him, both on the driver's side and the passenger side. They got the information after that fact. They had to deal with that information immediately upon contact with the person. They couldn't step back and then initiate a high-risk traffic stop. The traffic stop was already initiated and they'd already come into contact with the complainant.
Good point, except it didn't read like that, and that was the issue. It didn't read like you suggested.
Sure.
Yeah,
That's
so
right.
it read as if they had gotten it, then exited their vehicle. And that's,
So given the clarification from the IG now, the additional explanation of what they intended you to read in this investigation, do you want to revise your motion of
To disagree and
that you disagree on allegation 1, or do you want to continue with that?
I'm not comfortable with that. With the discussion here, if we have made a recommendation from our committee.
Exactly.
If that is not correct, then I would like an official response, because an officer drew their weapon. In our investigation, we found a policy violation and a safety violation, actually. Now, our discussion here has been great, but it is not cleared out in my mind by any means.
Yeah, I'll just
So,
follow up briefly here on this. So I think regardless, this situation seemed like there's some escalation here that it thankfully didn't turn out worse. But to me, seems like a policy violation. I would defer to the subcommittee in terms of the decision you all are making moving forward here. I would like, a little more finding consistency in terms of what we're getting from the IG's office and what you all are finding. And so maybe in the future, just as we send those kind of questions and follow-ups, like just getting some insights and making sure that that policy is included here in this report itself. But I'd be perfectly in favor of deferring with and your all's decision to sustain that first one, which is disagreeing with the finding, and then to sustain the second, which is agreeing with the second allegation.
Do we have
Does
a,
the IG's office still believe that your position is the correct one, given this conversation?
The board is voting on the report, whatever the board agrees and the subcommittee wants to do going forward. I will say at this point, the IG has no, if that's what you want to do, I would say go right ahead.
all right, so,
Always going to agree.
and we don't have to.
And we don't
You
have to.
But we can go ahead and take a vote on this one because it is a little different from the other ones that you have where you completely agree with the IG. And so on, did you already make a motion?
Yes.
Did we get a second?
Second.
Okay, now we have a motion. Are you shaking your head no? We didn't have a motion? So we did not have a motion.
I thought I did. Oh, Lord. All right. We move to accept the findings of the Department of the Inspector General as to allegation number 2. As to allegation number 1, we move to sustain the complainant's allegation. We believe that the officer violated a police directive for high-risk traffic felony stop. And we also recommend that the officer review the Traffic Crash Investigation Directive number 5.05, plus he should review vehicle stops and approaches, Chapter 5, Issue 2.
So wait a second. Okay. I just have one question about that because there are specific recommendations for the individual officer. Are we allowed to do that in the motions?
I think we talked about this before about whether you can make specific recommendations or not. I think that's more for the discipline side of things, but in
Okay,
terms of like
okay.
reviewing policy, that's okay? Or
Mary,
should they stay?
would you
away
like
from
to amend your motion to exclude the disciplinary part?
I
Yeah,
would at
think
this
we
time
just- right,
amend
Just
my
finding a
motion.
violation is probably the appropriate way to go.
All right, okay.
I will simply amend the motion as to allegation number 1. We will simply sustain the complainant's motion.
All right, those in favor, please raise your hand. Those not, those abstaining. All right, let's take a 10-minute break. Let's come back at like 3:51.
Do not agree.
What does that say?
No, I abstain. Case number 228.
Yes, that's me.
All right.
2023-0228, the statement of facts. On March 3rd, 2023, the Department of the Inspector General received a complaint alleging police misconduct. Officer failed to make an accurate accident police report. The DIG requested unit history CAD data indicating injury accident on Carl and Morris. 4 cruisers were assigned to this run. The BWC footage reviewed as to who was at fault, and the driver was not able to be determined as to who was at fault. The 2 drivers had conflicting stories. The passenger in the complainant's car was transported to the hospital. So in this case, the officers were interviewed. Officer G interviewed, he took the report. The procedure is to clear, and this is what he indicated when he was interviewed. He said the procedure is to clear the location for traffic flow, determine if there are any injuries, if the vehicle should be moved, determine who's at fault, and finally follow up at the hospital. In this case, all the officers collectively could not determine who was at fault. Both drivers said they had the green light. 1 passenger was transported. The ID interviewed Sergeant. She was Officer G's supervisor. She received a call from the complainant at headquarters. She explained to them that the original report, which is what the complainant had somehow gotten a hold of the report before, the complainant had this report, and I'll explain in a minute, and it was not clear on that report the direction of travel, what the direction of travel was, and the report that she had not been approved by the sergeant. When the sergeant got it, she corrected the typos, she clarified the report, and she approved it. The report does not become official until it is approved by the sergeant and sent to the state of Ohio. Somehow, this particular complainant got the report before it was approved by the sergeant and before it became official. She had a copy of this report. The sergeant then went on to say that the report that was inaccurate had not been approved and had not been sent to the state of Ohio. The finding of the IG was that the initial report received by the complainant was not approved. It was not sent to the state of Ohio. The report was revised by the sergeant. At fault could not be determined, and the officer had the right. The officer has right to do that if evidence and statements are not consistent. Officers' actions are within policy and procedure, thus the finding is unfounded. Our committee agrees with this. We move to accept the finding of the IG as to case number 2023-0228.
Thank you. Is there a second?
Second.
Right, it has been moved by Mary and seconded by Fluharty. Next case would be 238.
This is DIG complaint number 223-0238. On March 6, 2023, the complainant filed a complaint with the City of Columbus Department of the Inspector General alleging misconduct by Columbus police officers. The complainant alleged that officers came to his apartment and threatened him about a harassment allegation reported by his neighbor. After a review of the body-worn camera footage of the involved officers' statements and CPD policies and procedures, the following is recommended. The Columbus DIG unfounded, as there is no evidence to substantiate the complainant's allegation. However, the investigation found evidence that substantiated the complainant's allegation that one of the officer's comments were threatening to the complainant and violated CPD policies, procedures, and/or law. Therefore, it is recommended that the allegation against that officer be closed with a finding of sustained. Allegation 1, the complainant alleged that officers came to his apartment and threatened him about a harassment allegation reported by his neighbor. After a review of the body-worn camera footage for that officer's statements and CPD policies and procedures, it is recommended the allegation be closed with a finding of unfounded. The investigation found no evidence that substantiated the complaint's allegation. Allegation 1A. The complainant alleged that officers came to his apartment and threatened him about a harassment allegation reported by his neighbor. A review of the body-worn camera footage for that officer showed that officer walking down the stairs, and the complainant was following closely behind the officer. The officer turned toward the complainant stating, "Don't effing walk up behind me either. Do something, do something. Don't ever walk up behind me. You walk up behind me, you get dropped." Based on the BWC footage, along with the statements from the complainant and responding officer, the investigation found there is evidence that substantiated the complainant's allegation that that officer's comments were threatening and violated CPD policies, procedures, and/or law. Therefore, it is recommended that the allegation be closed with a finding of sustained. Our committee agrees with the Inspector General, and I move to concur.
Is there a second? Second. It's been moved by Mark, seconded by Mary. Case 247.
On March 8, 2022, the complainant filed a complaint with the City of Columbus Department of the Inspector General alleging misconduct by Columbus police officers. The complainant alleged that on March 6, 2023, the responding officers did not adequately secure a breaking and entering crime scene that occurred at his restaurant. The complainant that alleged about 4:30 a.m., his employees walked in his restaurant and noticed the drive-through window was open and the cash register was on the floor. The complainant alleges when the police arrived, they asked the employees if everything was okay and left the restaurant. The complainant alleges the officer did not walk around the premises or the parking lot and did not check inside the building. The investigation revealed the responding officers, upon arriving at the scene, walked around the building, checked the doors on the restaurant, checked the drive-through window, and checked the vehicles that were in the restaurant parking lot. Additionally, the officers spoke with a female employee of the restaurant who informed the officers that there were only 3 people inside, everything was okay, and nothing was stolen. After a review of the body-worn camera footage, computer-aided dispatch reports, case report summary, preliminary investigation report, and CPD policies and procedures, the following is recommended. It is recommended that the allegation be found exonerated, and as both officers' actions were supported by CDP policies and/or laws. Our committee concurs, and I motion to support the IG's findings.
Second.
Thank you. It's been moved by Mark, seconded by Mac. All right, Mac, 279.
Case number 0279. In this case, officers were responding to a dispute between a couple at an apartment complex. At some point, one of the officers leaves the residence to retrieve something from his cruiser. While outside, the property manager asked the officer what was going on, and the officer states to that manager, "It's police business, sir. This is their lives. I just can't tell you what's going on just because you work here. It is not your business. It's a private matter." That individual then goes back and tells a coworker what happened. That coworker then files a complaint with the IG stating that CPD officers treated the property manager rude by shutting the door in his face, when in actuality, the officer closed the door after he went back into the apartment. And after a review of the BWC footage of the involved officers and CPD policies and procedures, the DIG recommends the allegation be closed with the finding of unfounded. Our committee concurred. There was no evidence to substantiate the allegation that the officer was rude. So I motion that we, the board, concur with the IG's finding of unfounded in case number 23-0279.
Second.
Thank you. It's been moved by Mac, seconded by Pastor Rich. All right, so does that conclude all your cases? Okay, so we have to vote on case number 143, 149, 172, 193, 228, 238, 247, and 279. These are all cases in which their subcommittee agreed with the findings of the IG's office. All those in favor, raise your hand. Thank you. All right, next set of cases. Mr. Strickland?
Hey. Thank you. So we have case 23293. So there's a couple of things in terms of how our subcommittee wants to do report outs moving forward and thinking about the best process to streamline the process here. So ahead of, after our subcommittee meets, so we meet monthly in between these monthly CRB meetings, we would then compile the notes from that particular case and then send out an investigation review and report out sheet from our subcommittee. Our subcommittee will have an overview of the report out, which handles the number of administrative closures that we have, the ones in which the review committee agrees with the Department of Inspector General recommendation, and then the one in which we would, in the language you're using here, we can probably change it, where the review committee disagrees with the recommendation. It will be on board members to review the particular summaries of those cases ahead of these meetings. And now, before I talk about giving everybody homework and a lot of homework, the idea is that right now the way the process works is that we have our subcommittee meetings in which we go into lengthy, full detail every month with these subcommittees. We have these conversations, we have these discussions, and then later we have a board meeting like this, and then we do the exact same thing, a little less detail, when the fact is that we as a board still defer mostly to the subcommittee in the ways in which we've operated in the past. The recommendation that I would have moving forward is that I would send out this review and report out sheet, and if folks had specific questions from there, that they could then read those cases and then bring that when we discuss it. The reason I'm saying that is because I think where I would like to spend the majority of my time, or the time, is on those cases where we do have disputes, like where we disagree as a body, and when we want to have further discussion there. So I'll provide an example of kind of what this looks like. And for those who are concerned about transparency, one of the big questions that people have, well, let's read them during these meetings to make sure that we're transparent. One of the things that we want to be able to do is that I would also potentially recommend is that we are clear to the complainants and the public that have filed cases that they have the opportunity to attend these meetings. And specifically, this is an added recommendation, that we would, and this would be an ask that I would have on the IG's office. I know it adds more work, or an ask that we would have with the Civilian Review Board, would notify complainants when their case will be heard. And so if they want to come into a meeting or a subcommittee meeting, they certainly can. They would still follow the same process that we would with any sort of city meeting, in which if they want to speak, there's an allocated time and all those different pieces there. So that would be my recommendation. I will walk through an example of what this looks like now. And if we have further concerns over what this can look like, we can modify it moving forward.
I just have
Yeah.
a couple of questions before you move forward.
Yes.
So are you saying that what you are going to do right now is not provide a summary of your cases?
Yeah, I'd provide an overview of the cases of 23293, 23295, 23326, 23330, 339, 354, and then 2368. an overview of where our committee accepted or rejected that particular recommendation. And then for the cases in which our subcommittee disagreed with the IG's recommendation, I would then provide the summary of those cases.
So then on the other ones, it's on the rest of the board to read what you sent.
Yeah, and so the idea would be that to streamline the process, and maybe there's a way we can do this where it's a PowerPoint or something like that, that people can just quickly read through the summaries, if they want to read further, or other board members, if they're interested in learning more about why we accept the recommendation, can join our subcommittee meetings where we're talking about these details in detail. And so that would be the recommendation moving forward. Just no, the recommendation is that you would read the summary before the meeting, if you would like. You don't have to, but that's the recommendation. And the reason being is because when we're reading out loud the summaries, I don't know about you all, but it's hard to keep track just verbally listening to summaries of what people are saying. And so unless something sticks out, that's when somebody might say, actually, I have a further question there. So the idea is that instead of at the meeting itself reading over summaries that we've already read over in our subcommittee meetings and that you all have potential access to, that is provided for. And the deference and it requires deference for subcommittees, it really does, is basically saying that there is a subcommittee that discussed this at length of 3 or more members to talk about these cases. They determined that they accepted the findings of the IG's office, which, by the way, the IG's office not only has the investigator doing the report, but then on top of it, the IG, the deputy, they all review these particular cases, and then that is sent to us to then cross the T's to dot the I's from there. And then we discuss that case at our subcommittee meetings. Then we go to our board meetings and we discuss it again. So my recommendation is streamlined to make these meetings more streamlined and focused in on what our subcommittee has determined to be at issue. That is where we would, that's where my recommendation would go.
Would you clarify what we would be discussing at the board meetings?
Yes, so we would discuss at the board meetings, at least based on one of the recommendations here, are either findings that we reject or modify the IG's recommendation, and or if we had additional notes or comments on specific cases. That's where we would, and so I can provide an example as to what that looks like.
Or additional allegations
Yes.
that you're adding.
Yes, exactly. So the idea then is that, that way these cases can move to CPD and the police chief, right? Like that, the goal is to move these cases along. If we have areas where we want to accept or modify the report, then that's an example that we could do that moving forward.
In all other cases that are just simple cases that we agree with, we would just list those case numbers and say, we agree with the IG's findings on case such and such, such and such, such and such. Instead of us sitting here being redundant and reading all of these summaries over again,
I think that's all a valid point, but I want to just bring everything to everybody's attention of something that happened during today's meeting. Mac's group had a case, and in that case, they actually agreed with the findings. But as he was giving the summary, it was the individuals here, particularly you, Kyle, that said you did not agree with the subcommittee's findings. And I don't think you would have known that unless it was for the summary that Mac provided. And so I think there is something to be said with the reading that does take place here. But I am curious to understand your process and to see you all give an example.
Yeah, no, it's an exactly right point, which is why I think the way ahead of our meetings, it would be on the subcommittees, to the chairs of the subcommittee to, just like we've done before, Mac's done it before too, is to say, hey, we agree with this, but there are some additional comments or notes that we would add here. And so that's the context, that's the relevant context. I only need the relevant context. I don't need the full summary of the case that I could also already read, right?
No, I
ahead of
completely
time.
agree with that, but I'm saying that without Mac's summary, you wouldn't have even had your questions.
It's possible I wouldn't have had my questions, but the idea though is that the IG's office completed a report and forwarded it along to the board, and so that's kind of where I don't want to get bogged down into those specifics of those specific cases, because even though I had questions, right, I
Well, you
wasn't
actually changed the subcommittee in terms of what their recommendations were.
Certainly, but at the end of the day, at least the way the process is set up now, that's still being forwarded along to the police chief, and they have that added allegation, but then they also have the report from the IG's office. And so we still, to this day, don't know how much weight a CRB sustained allegation is given versus it coming directly from the IG's office. So that to me can streamline this process, where we're not necessarily using language of we agree or disagree with the findings of the IG's office, but instead maybe the language is we accept the IG's office closing report, whatever the investigative memo is, or we modify the closing report and you modify it with specific language from the CPRB. That way the report, when it's given to us, is more of a close to final draft, but ultimately it still goes through the process prior to it being fully submitted to the CRB. And at the end of the day, it is on us to review those cases if we would like to, but it's just not feasible, the amount of cases coming in, for us to review the summary 2 times every time.
Yes.
I also would like to hear how Kyle's recommendation will work. But just a couple things.
Yeah.
As far as the public that we are supposed to serve and the officers whose the allegations are being brought against, it seems like the public has the right to come now to our meetings. I don't know about yours, but no one has ever shown up at ours.
We've had some at
Do they
ours,
really?
too.
Okay.
And these are also streamed online too, and people can watch it on
They
the
can
public
watch it
access
online.
channel as well.
Okay.
Yeah, so they can, so as we're given the summary, they can hear it from those different venues.
Okay, you're talking about the subcommittee hearings.
We've had people show up at our subcommittee hearings also.
Have they? Okay.
Yes.
So far, we haven't had any show up, but neither here nor there. But what I'm a little uncomfortable with is that reading, for us to read summaries and then just discuss with the full board, not have the exchange of ideas and the ability, just like the example you gave, the ability to have the 11 of us discuss the facts and bring all of our collective, no matter how petty the case might seem, but to contribute to that case and discuss it. Because each one of us is going to be, we all have responsibilities. Are we all going to give what we need to give to those summaries and then only come here and discuss those that we might have an issue with? And that's that. Are we really, is the public really getting what they deserve from us?
Yes. And here's my thought on that, is that we prioritize what we want to have substantive conversations about. Right now, it is difficult, if you're a member of the public, to keep track of all that's going on, because we're reading a lot of different cases, we're reading summary, we're moving through it, versus a process in which we are communicating. And now look, this also will require, I think, on the city to figure out ways to be more transparent, whether it's through the public dashboard or database, so that they know ahead of every meeting, these are going to be the cases that we are going to discuss, and potentially you click and can see the summary of those cases and what was decided on from there. And so that's really where, just from a pure prioritization perspective and an efficiency perspective, let's say we have thousands and thousands and thousands of cases. It is inefficient for us to read a summary. By the way, we're already doing it. I mean, I think that even our subcommittee meetings and between these meetings are somewhat redundant, but we're already doing it. And so I don't think we need to do it again at the full board meeting.
But I think there are different purposes for reading these, and I'm not going to belabor this conversation much longer because you should have been going over your cases by now. But there are different reasons for reading it. So we read them here because it's not just for us, but it is for the broader public, either whether they're watching online or watching through the public access channel or things like that. And I think we just need to be mindful of that. The other thing is that we do not have that public dashboard created yet, and we do not have a mechanism in place for which the public is readily updated on the status of cases, whether or not there's cases have been heard, and those different things. And so I think with this format that you are proposing, I think that needs to be taken into consideration, the infrastructure that we currently have versus the infrastructure that we would like to see in the future. And maybe that might be more feasible for that time. But that said, I would like you all to start going over your cases.
Excellent. I think Stephanie might have had a.
I just wanted you guys to know the agendas and the minutes are posted online, so they have an expectation of when their cases are going to be heard.
Yeah.
I mean, they are posted, we're just
Yeah.
not getting there.
Yeah, no, and that's
Yeah.
a great point. So I think that would be, again, this is subject to public records. There's opportunities to review these cases. I do think the amendment I will also have on this is that I know right now the way the process works is that after you all complete the investigation, you then contact the complainant and say that it's, going to go to the CRB and then go to the police chief. Thinking about that process just on our end in terms of, because if you were complaining, you received that information, you would kind of think that that's the disposition, like that is close to the final disposition. And then, so I just want to think about different ways so that that process is done in a way in which we're not off, we're more on the same page. So maybe we're accepting the draft of that memo. But again, that requires us as a board to not slow you all down, right? And so, which is why I'm trying to move this ahead. So I'll go over this particular set of cases. So from our report out, our review committee accepts the Department of Inspector General recommendations for cases number 23293, 23295, 23326, 23330, 23339, 23354, and so just those cases. We had additional comments on cases 23368 of these remaining August assigned cases. There's other cases we have in later cases that we can talk about, but of those cases, we had additional comments on 23368, and this is where I would give you the summary and the context, right? So as to what those comments are, but in terms of those first set of cases that I listed, we would accept the recommendation of the IG's office. And just for clarity there, our group met, we discussed these cases at length, and there was no particular issues that we had with these cases, and that's why we decided to move forward with accepting the recommendation. So folks are comfortable with in terms of the summary for case number 23368, which we had some additional comments on, I'll give you a summary. So this is case number 23368. On March 2023, the complainant filed a complaint with the City of Columbus Department of Inspector General's office alleging excessive force. The complainant alleges that on February 13, 2023, he made a call to a suicide hotline. When Columbus police officers knocked on his door, the complainant stated he allowed the officers to enter his apartment, and at some point it was determined by the officers the complainant was to be taken into custody. While taken into custody, the complainant alleges he was slammed into a door. Also, the complainant alleges he was handcuffed and received damage to his right hand and arm, including abrasions, bruising, and numbness. The complainant stated he was transported to a hospital and sedated against his will. After review of the footage, the computer-aided dispatch, and the case report summary, CPD policies and procedures, and the complainant, the following was recommended. The Department of Inspector General found no evidence to substantiate both the allegations by the complainant. Therefore, it is recommended that the allegations be closed with a finding of unfounded. In particular, they explained that in this case, that there was no evidence as they reviewed the process for this case. While detaining the complainant, he was stood up by officers against the door, and officers were applying handcuffs. The officers reassured the complainant they were not going to hurt him. And then the Columbus Department Inspector General observed no evidence that substantiated the complainant's allegation he was slammed into a door. The complainant was told, quote, the complainant said, quote, "You are hurting my wrists right now," and the officers advised the complainant to stop moving and to relax your arms. The officers are heard reminding the complainant they were not going to hurt him. On arrival, one of the officers escorted the complainant into Riverside Hospital because they were experiencing a mental health crisis. The complainant was escorted into the room and the handcuffs were removed. The Department Inspector General observed no evidence that substantiated the allegation that the officers damaged the complainant's hand. They also reviewed all the footage to the responding officers, and the Department Inspector General found no evidence that an officer used excessive force during their interaction with the complainant. And so their findings were unfounded. We had additional questions for case number 23368, which was broader than just the Department Inspector General. It was a citywide kind of question, which is where does the city stand with respects to alternative response models or other crisis response models to these types of situations? Because this is a type of situation that maybe other entities might have been involved or could have been involved. And so that's just something that we want to put just generally for the record, want to know where the city is at on this. I know there's a variety of different response models, maybe something public safety director could look at. And then we had a question just generally about does the Department Inspector General's office have a standard follow-up and referral process if a complainant needs mental health resources and support? And I know there's some of that in terms of if a complainant files a complaint and the IG's office makes a particular finding, you can still refer them to other entities or resources if they need it. So that was our additional comments. As far as the other cases, we did not have any additional comments or notes that warranted further discussion. So that is how we would move forward on all of those cases that I just mentioned.
I have a question. Did you send out the review sheets for the other cases?
The report out, yeah.
You did. Did we get those?
Sorry, what do you mean? Yeah, just I sent out the report out.
That's what I was just trying to find them. Thank you.
Mr. Tobias, is there any reason why this particular procedure is not
I would just like to interject really quick before you
sure,
move forward with your questions.
Sure.
I do have a concern that there was no notice brought to the board that you were going to change the format so that the board could adequately prepare for this new proposed change that you are doing. And as a result of that, I don't think that we should take a vote at this time on those cases until we are assured that the board has had the opportunity to actually review all of those cases.
Well, I'm happy to also read out the summaries like we've done in each of the cases. I can quickly read those out, and we'll come to the same determination. But happy to read out the summaries as well.
Would you like to? Just wait my turn. I would prefer, at least for this one, that you did read out the summary, or we just not vote on them until. No, I mean we did the work, right? So it's really on just reading the summaries again, but yeah, I'm not sure. All right.
So the first thing I'll say in terms of process, if ultimately this is going to be what happens, at a minimum, you should read what the finding of the IG was.
Got it.
And then everybody on the board knows what the finding was and that you're in agreement with that finding, so they know what they're voting on.
Got it.
Frankly, I would probably want to think about it and offer an opinion at some other point in terms of whether that's something the this particular committee can impose on the rest of the board, or whether it is something, I don't know whether I look in the bylaws or Robert's Rules of Order or both, as to whether that's something that, because it's one committee of three, that it's something that the board should vote on as a whole in terms of the process for all the committees being consistent. I want to think on that and consider, maybe talk to Ms. Ross, who's a lot smarter than me. So yeah, that's what I would offer, at least for
Okay.
now. I mean,
I'll read.
Mr. Strickland is offering to read them. Otherwise, I'd say the other option is you could table them to give the board time to read them. But with 33 minutes left, that's the chair's decision. And ultimately, also, in terms of whether to call a vote on those, that's within the authority of the chair, whether to call that vote or not.
Yeah. Well, yeah, I'm happy to read through them just so that we can compare.
Well, Kyle, you're the one that's saying that you always want to move these forward.
Yeah,
So
no, I know. So,
I would like
yeah.
you to read them.
Exactly. No, exactly. So I'm just saying there was that process that I just mentioned, which takes less than 5 minutes, and then there's this process. So here we go. Yeah.
Have you discussed your questions in advance with the
We don't have-
Inspector General?
There-
You have,
You just read off questions.
you read questions that you had for the Inspector General. Our procedure was that if you have questions, you email
Thank you,
her,
Mayor.
you get your response,
Thank you.
and
Mayor.
then,
These questions, I don't need a response in any time soon. I mean, that's the question whether the city has alternative response models. Where's the update? Where are we at on that? That's not a particularly urgent question that the IG's office would have an answer for. That might be something for the director. That might be something that I can find out. I mean, this was just a note or a comment or a question that I have. And the other question regarding the referral process was an additional note or comment that I had. It was not at all dispositive on, would not change the outcome of this particular process. And so, I don't, there's no further questions we have of the IG's office. We met as a subcommittee. These were what came up. There is a case that is not until the review of August assigned cases that we do have concerns about and we would like to discuss, but I don't think we're going to get there. I was hoping to get there by streamlining this process, but because we've had 13 cases for this last one. But I'm happy to read through quickly, 23293. The other problem, I'll just say on the summaries, when we do the summaries, is that it's inconsistent. There are inconsistent summaries just based on who an investigator might be. I know they're more streamlined moving forward. But I will also say, even as you read the summaries, there can be gaps missed there. So, which is why it's important for us to also be able to defer to subcommittees. Here we go, 293. On March 2023, the complainant filed a complaint with City of Columbus Department Inspector General alleging force by a Columbus police officer. The complainant alleged that her sister received stitches and suffered a broken jaw after interacting with police and questioning why one of her friends was pulled over for reckless driving. Also, the complainant alleged her sister was not arguing with the officer, nor was she physical with the officer, but that the officer was arguing with her sister and threw her sister to the ground. In addition, the complainant stated that one identified female officer with blonde hair arrested her sister, and another officer whose name was not on any paperwork conducted the arrest. The complainant stated that she was not at the scene when the incident occurred. The Department Inspector General conducted an investigation that consisted of a review of the body-worn camera footage of the involved officers, a computer-aided dispatch report, and the case report summarizing the statements of the involved officers. The Department Inspector General reached out to the complainant and her sister, requesting an interview with the sister and information about the alleged broken jaw. The complainant's sister never contacted the Department Inspector General. Therefore, no interview was conducted and no information was provided about the alleged broken jaw. The investigation found that the complainant's sister was arrested by CPD officers for interfering while the officers were conducting a sobriety test on the driver. The sister was instructed by the officers to back up and stop interfering, but the sister refused and was arrested. During the sister's arrest, she resisted and was taken to the ground and handcuffed by CPD officers. The sister suffered a laceration to her chin during the arrest. Medics were called and responded to the scene, and the sister was transported to Grant Medical Center. The Columbus Department Inspector General concludes that the officers' actions during the arrest were in accordance with CPD policies and procedures. The complainant alleged her sister suffered a broken jaw during her interaction, but the investigation found no evidence to corroborate the complainant's allegation. Therefore, it is recommended that this allegation be closed with a finding of unfounded. The complainant alleged a female officer with blonde hair arrested her sister, and the officer's name was not on any paperwork indicating she conducted the arrest. However, the investigation found that a female officer spoke with the complainant's sister. After the female officer assisted another officer in apprehending the complainant's sister, while the officer applied handcuffs but did not make the arrest or issue the summons to appear in the court for the obstruction of official business charge. Therefore, it is recommended that this allegation against the female officer be closed with a finding of unfounded. Lastly, the complainant alleged her sister was not arguing with the officer, nor was she physical with the officer, and that the officer was arguing with her sister and threw her to the ground. Notably, the complainant stated that she was not present when the incident occurred. The body-worn camera footage from both officers shows the complainant's sister arguing with officers and resisting being handcuffed by the officers. The officer took the sister to the ground using a level 1 armbar technique and handcuffed the sister. The body-worn camera shows that there were no officers arguing with the sister, but they did advise her to back away. A review of body-worn camera footage, use of force report, and case summary report found the officer's statements consistent with the information reviewed. Therefore, it is recommended that this finding be closed regarding the officers using force against the sister be closed with a finding of exonerated. Additionally, the investigation found no evidence that the officers were arguing with the complainant's sister. Then it goes into a whole host of walking through the situation, and that they were trying to conduct a sobriety test, and that somebody was, they were struggling to kind of restrain the individual, and then that ultimately this technique was performed, but that there were no, every other allegation was unfounded. And so one of the, it walks through the use of force level and explains what was utilized here, and then walks through each allegation. So, as discussed here, and as we would discuss, hearing the summary initially, as we saw that summary in terms of wondering why the use of force was used here, and was that necessary, all these points were discussed among our subcommittee. Reviewing the full case, you see the process of how the IG's office came to the findings that they came to, and our subcommittee agreed with the findings of, I'm just going to walk through specifically here, the findings of unfounded allegation 1, which is that there was no evidence to substantiate the complainant's allegation that her sister suffered a broken jaw. Allegation 2, regarding one of the unidentified female officers arresting the sister, and her officer's name was not on any paperwork stating she conducted the arrest. However, that officer is mentioned on various documents pertaining to this arrest, and so after review of the footage, their recommendation is closed with a finding of unfounded. And the third allegation here is that related to the allegation of being thrown to the ground by the officers, and she was thrown to the ground by the officers, the body-worn camera footage from both officers showed that the complainant did not comply with the officer's instructions, and when the officers attempted to apprehend the complainant to arrest her, she resisted being handcuffed. The officer took the complainant to the ground using a level 1 armbar technique and handcuffed her. The review of the body-worn camera footage, the use of force report, and a case summary were a report with statements given by the officers, and that is determined to be within use of force policy, so it's a recommendation that the allegation be closed with a finding of exonerated, as the officers' use of force actions in this incident are supported by CPD policies and procedures. And what I would do in a case like this is, what comes to mind is policy, and looking at, okay, if this is found within policy and we have concerns with the policy, then that's a broader question. But as far as whether or not these actions were a violation of policy, it was determined not to be a violation of existing policy, and we agreed with that finding. summary for case 293. I'll make a motion to accept the IG's office finding for case number 293.
Second.
Thank you, appreciate that. We now have case number 295. So on March 2023, Department Inspector General received a complaint via the website that alleged that a Columbus police officer refused to wear a protective mask while conducting guard duty at a hospital. We've had several of these instances come up. The Department Inspector General initiated this complaint or this investigation, and it revealed the following. In regards to allegation 1, the complainant alleged that a Columbus police officer refused to wear a protective mask while conducting guard duty at a hospital. The pandemic policy orders COVID policy for wearing masks at health facilities asks that personnel follow the face covering and PPE requirements of the appointing authority. An update was relayed divisional-wide via email with an effective date May 1, 2022, stating, quote, division personnel shall continue to follow the City of Columbus COVID-19 safe work practice guidance. The Columbus Department Inspector General concluded that the officer's actions violated CPD policies and procedures. Therefore, it is recommended that the allegation be closed with a finding of sustained. In regards to allegation 2, the Columbus Department Inspector General concludes the officer's actions of refusing to wear a mask after being asked to wear one by hospital personnel was unprofessional and discourteous, this being a violation of CPD policy and procedures. Therefore, it is recommended that the allegation be closed with a finding of, quote, of sustained. In regards to allegation 3, the investigation found no evidence to support the complaint's allegation the officer meant to intimidate her. Therefore, it is recommended that the allegation be closed with a finding of unfounded. So that's, again, sustained on allegation 1, allegation 2 sustained, and allegation 3 unfounded for case number 295. And I move to accept the IG's recommendations for those cases, for that case.
I just got one question about that. We had a similar case in which the individual officer left, and so that's why, you know, it wasn't a violation of policy. So did this officer stay and just simply refuse?
Yeah, there were several requests of the officer to wear a mask, and that there was multiple requests. Then he was kind of delaying the process. I'm gonna read to the specific point where the recommendation is made here. Yeah, I mean, other officers were asked to wear a mask, and they did. I'm just trying to look through the specifics here if we know this case, 295. There was I just want to make sure I'm clear here, so just make sure I'm reading it correctly. Yeah, okay, here it is, allegation 1. The officer admitted he refused to wear the mask when asked by the complainant during his interview with the Columbus Department Inspector General. And it was also determined that his actions of refusing to wear a mask after being asked by the hospital personnel was unprofessional, which is why it's recommended an allegation be closed with a finding of sustained. So this is different than that other particular case in which somebody was asked to wear a mask, they refused to, and they left. is my understanding. I don't know if the Department Inspector General has further pieces to add there.
I was trying to look, but I know on one of the cases when the officer was asked, he admitted, which was, you know.
He didn't say he was going to leave. He just refused to wear a mask.
Okay.
Yeah, he took the mask and put it in the trash can, and then he was asked to wear another mask. He put it in the trash can as well. So you know, it was repeated, pretty blatant here. Okay. I think did I make a motion?
Yeah, you did.
Okay.
Your next case.
Next case is 326. Summary here, on March 2023, the Columbus Department of Inspector Generals received a complaint of misconduct via the hotline. Complainant stated that on several occasions he has called the police because a neighbor is violating the protective order that he has against him. The complainant alleged that the officers aren't doing anything each time they come out telling him they need proof. Department Inspector General reviewed the evidence and determined that the complainant did not have a protective order in the initial calls for service, but that those calls were handled according to CPD policies and procedures. When the complainant obtained their protective order, they were advised per CPD policy and procedure to go to the prosecutor's office to violate if there was a violation of the protective order. Therefore, it is recommended that this complaint be closed with a finding of unfounded, as the complainant did not have a protective order when the issues began, and even after obtaining the protective order, the complainant was notified by the officers. There was kind of a grammatical error that the officer did not do anything that is refuted by the evidence. Therefore, it's a recommended with a founding of unfounded for allegation 1, which is that they didn't do anything related to the complainant's call for service. That would be my recommend. I would recommend to accept the IG's memo report for case number 326, 23326.
Is there a second?
Second.
All right. Thank you.
Case 23330. This is a case where a complaint alleged on January 4th, 2023, his house was raided and ransacked by Columbus SWAT officers, and the officers had approached him in an inappropriate manner. Also, the complainant claims a maintenance worker for the townhomes of his residence offered a key to the officers for his townhome, but the officers refused his assistance and continued to break into his house. The complainant stated the officers took some firearms that belonged to him, and whenever he calls the detective of the investigation, he is told by the detective that he can get the item, quote, this week or, in quote, next week, or quote, next week. After reviewing photos of the damage to the home taken by SWATs, a number of other entry reports, the case summary report and body-worn camera footage, the Department Inspector General concluded the following. The Department Inspector General found no evidence to substantiate the complainant's allegation that his home was ransacked by SWAT officers. The investigation found SWAT officers executed a search warrant at the complainant's residence. The lock on the front door was damaged when the door was forced open with the ram. A locked bedroom door was forced open on the second floor, damaged the door and frame, and a gun safe was damaged when forced open by the officers. The investigation found the officers' actions are supported by CPD policies and procedures and/or laws. Therefore, it is recommended that the officers be found exonerated of the reported complaint. The Department Inspector General also found no evidence to substantiate the complaint's allegation that the officers approached him inappropriately, and a maintenance worker offered a key to the officers, but the officers refused. In review of the body-worn camera footage, the premises was not occupied during the execution of the search warrant by the SWAT officers, nor did the Department Inspector General observe any person approach the officers offering a key for entry to the premises. Also, the complainant stated neither he nor his wife were home at the time of the incident. Therefore, it's recommendation that this allegation be closed with a finding of unfounded. The complainant alleged that the officers took his firearms. He was told by a detective he can retrieve his firearms, quote, this week / next week. On April 2023, the Department of Inspector General talked with the lieutenant, who stated he advised the complainant he would be able to retrieve his firearms after the investigation was completed. As a result, the complainant informed Department Inspector General that he wished to withdraw his complaint. Therefore, it is recommended that this allegation be closed with withdrawn. My motion would be to accept the Department of Inspector General's findings on case number 330.
Is there a second?
Second.
Thank you.
Case number 339, Department Inspector General received a complaint alleging that an officer who responded to a custody exchange was rude and made threats to him for no reason. He alleged that the officer kept leaving and coming back inside of the house and escalating the situation. After review of the computer-aided dispatch, body-worn camera footage, and relevant policies to determine if the officer's actions were in accordance with CPD policy and procedures, the investigation revealed the officer was not rude, did not make any threats, and did not continue to go in and out of the complainant's home as alleged. The language there that I would like to see is something like the evidence does not reveal versus like specifically saying was not. Therefore, it's recommended this case be closed with a finding of unfounded for both allegations. And then there is a extensive, process walking through this particular case. Based on what we saw, the actions did not rise. Did not rise to the level here specifically. They observed no behaviors that would be construed as rude in this particular instance. And the comment, basically there's a comment that was made that was not a threat, since his actions could have turned into interference of custody. Therefore, it is recommended that the allegation be closed of unfounded. In this case, we didn't have any concerns as a subcommittee reviewing this particular instance. So our motion would be on case number 339 to accept the finding of unfounded for allegations 1 and 2.
Is there a second?
Second.
Thank you.
All right, almost there. 354. This complaint was alleging that she had a protection order against the father of her child, and that on March 27, 2023, she was at a physician's appointment with the child and the father arrived. The complainant claims that police were called to the scene and the father was not arrested, but should have been arrested for a violation of protective order. After review of the computer-aided dispatch report, Licking County protection order, Franklin County court documents, and body-worn camera footage from the responding officers, the investigation revealed the following: that the officer consulted with and received directions from a judge not to arrest, but release the father from being retained in the police unit. Therefore, it is recommended that the allegation reported against the officer be closed with a finding of unfounded. And our subcommittee would motion to accept the recommendation by the IG's office for case number 354.
Second.
Thank you.
Those are
So-
all of our August cases.
Okay, and then what was your because we didn't vote on 368.
Well, I would motion to accept the findings for
Agreement, that's
368.
okay. All right, so for case number,
Still need a second on 368?
yes,
I second.
thank you. All right, so for cases number 293, 295, 326, 330, 339, 354, and 368, it has been moved and second to accept the recommendations of the IG's office. All those in favor, show of hands. All right, thank you. All right, we are right at 4:50, so there's a couple of things that we need to do in terms of housekeeping. Pastor Nathan, you had a question about the case. Huh?
My name is Tatum.
Tatum, I'm sorry, sorry. Reverend Tatum.
Yes, ma'am.
You had a question about the case that Director Brashadi had mentioned, and you said you wanted to know what that case was. You want to?
Yes, going back to the IG, if you remember when Director was here, she said that you and there was a case coming up that was going to be, I guess, going for discipline. What is that case? I just want to know what.
So, we had a case So we had a case that went before the board involving an allegation involving the chief of police. So in that case, instead of forwarding that to the chief of police, my recommendation was that that was forwarded to the director of public safety, and that was the case she would be referring to. Any case that we review that may involve an allegation involving the chief of police, we recommend that that goes to the director.
assistant chief of police?
I believe this case that we're talking about was probably the one involving the,
Was it the game? Was it the Ohio State
yeah,
game?
Yeah, it was.
yes,
Yeah,
yeah.
okay.
So that's the one, because there's,
Chief Bryan.
yeah, to the chief Brian. And so there is a process, oh.
Bless you.
So there is a process, anything that involves an officer goes through the chain of command, and then whatever disciplinary actions will come of that has to go through some type of collective bargaining agreement. That may end up going to the director's level, I don't know, because I'm not as familiar with that. But anything involving the chiefs directly, we forward that. Our recommendation is always that that goes directly to the director.
All right, that's the only question I had. I just wanted to know what particular case that was.
Thank you, Reverend Tatum. And then Pastor Nathan, we had case 0224 that we did still need to take a vote on, and that was with the other hospital incident and the officer not wearing the mask, and
Right, so-
he left.
So I thought we had moved to accept the IG's findings in light of the fact that he left.
Correct. So we just need to vote on it.
Okay, so, and we had a second on it?
Do we have a second? Second by Pastor, Reverend Tatum. Thank you. All those in favor, show of hands. All right, thank you. So got those out of the way. Your case assignments, yes.
There are a number of cases here, not a significant number, but there are a number of cases that are from 2022 that we have not, like, that we reviewed as a subcommittee, but we haven't discussed. And I know that was supposed to be for today, but I am a little concerned that we are delaying those cases since they were already delayed, right? So we have a number of cases from 2022. I think there might have been some sort of issue where there was some oversight, but just the
Yeah.
2022 cases is where.
These cases were assigned for the August meeting, yes. So we're going to be tabling those to the next meeting.
But I think there was, like, those cases probably should have been assigned a long time ago. So I worry that we are going to delay these even further if maybe the priority is that we read those cases. Because I just don't want to be in a situation where we're even further behind on the 2022 cases.
Okay. So for the case assignments that we have for moving forward here, Committee 1, 0089, 0347, 0364, 0366, 0385, 0388, 0598, 0651, 0665, and 700. For Committee Number 2, you have 0474, 0551, 0569. 569, 0589, 0593, 0602, 0664, 0667, 0672, and 0703. And then Committee Number 3, your assigned cases are 0560, 0603, 0604, 0631, 0641, 0649, 0445, 0670, 0725, and 0729. And that brings us, our next meeting will be held on Tuesday, October 3rd, same time, same room. And that brings us to the conclusion of our meeting. Can I get a motion? Yes. We did.
I just request ahead of our next meeting, I don't know if it's possible, we need to submit a formal request, but I would like to see on a policy front, seeing what CPD's policies are regarding, situations involving vehicles. The concern that I have, seeing what the police shooting of Takai Young, Blendon Township police shooting is a concern. And so I just want to make sure that I get a sense of what CPD policies and procedures are generally around those types of incidents or situations.
Could you be a little bit more specific so we know exactly what you provide? Because there were a lot of things that happened, and so like what exactly would you like to have a policy on?
I mean, one, in terms of trying to get an understanding in terms of one, there's Blendon Police Township's policy around this, right? And then
Around what?
around related to what officers do in these situations in which somebody is in a vehicle and whether or not use of force can be deemed justified in a particular situation.
So you want to know CPD's policies in terms of an alleged suspect in a vehicle?
Are you trying to say what an officer
Or
should
use-
do
use of
in that
force?
situation? Should he?
No, yeah, I'm basically, I just want to make sure that we're, that we're reviewing policies of CPD. Again, I mean, this is an instance that happened here in Central Ohio, wasn't involving CPD, but this is just, I want to know in terms of what, we've got, there's the Blendon Township policy. I want to know what CPD policy is, other best practice policies more broadly. That would be helpful just to know.
So I think if you could tell us specifically what policy, and when you keep saying Blendon Township policy, what exactly are you referring to?
So, I don't need to get into the specifics of the situation, right? And
But you did mention Blendon Township, so I'm just trying to get a better understanding of what you are requesting, so that way we can provide it.
Yeah.
A vehicle, is that what?
Yeah,
you're
the
saying?
use
So
of
you're saying
force.
Blendon Township policy, and you want to see what CPD's policy is for use of force?
Yeah, 100%. Yes.
Okay.
I mean, I think that's a legitimate question to have. I mean, I think the reason I ask that is because you have a number of different agencies weighing in on a particular situation, and I want to know what CPD policies are.
We had
generally.
a use of force presentation, but we definitely could see if we can get a refresher on that.
They didn't say anything about vehicles though in that, did they?
That's
How they handle people in vehicles when it comes to use of force. And I think that that's what this incident is more so about, is about the shooting of this young lady, who was in a car. So I think that's kind of what we're talking about here.
Yeah, I mean,
Those types, what is the policy when you're dealing with a combatant individual using a car?
So I don't know it verbatim, but I can say, generally speaking.
Yeah.
We get out of the pathway.
Yeah.
Okay.
That was my understanding.
I mean.
No, look,
No.
I mean,
that's
because
common sense.
my understanding is even you look at Blendon Township policy, but my understanding of a particular policy is that if there's reasonable means to move out the way, that force isn't necessary, in a particular instance. So I just want to know,
I think you make a good point, and I
Yeah.
think you're also getting onto the bigger question of what tactics do officers use to compel compliance against individuals? Because he was trying to get her out of the car, you notice he pulled the gun and said, "Get out of the car." So I think that also factors into this too, and so
Yeah.
whether or not that's a good tactic or not,
Yeah, and I don't think so. So it would be helpful to know where CPD is at on whether it's policy or tactics in this situation.
We'll let you, right?
I know we're over time, Doug, but we had asked before, a question was brought to this board about trying to get the chief of police to come and visit with us. Has
Yes.
anybody heard anything about that?
I believe they are still working on that. I think they're still trying to identify a date, but the request has been put out. Yes. All right. Motion to adjourn?
Second. I make the motion.
All right, we have a motion and we have a second? And we have a second. That was our meeting. Thanks, everybody.